All right, well, I'm delighted to be here this evening to visit with you about some important topics. And so what we decided to do in connection with the other presentations is to focus in on primarily two areas. One is on the area of advanced planning and end-of-life planning, planning for incapacity, those type of issues. And then we'll talk a little bit at the end about the whole area of abuse, elder abuse and neglect. I'm an attorney, so as always, we've got to have some kind of disclaimer, and here's mine. In short, it basically says that what I'm giving you tonight is not legal advice. It's information of a general nature that can help you to sort of plan your affairs and make decisions. But if you do have a specific legal issue, you will need to seek counsel from an attorney that can look at your particular case. So looking at getting our house in order, we're going to focus primarily on healthcare decision making and planning. We'll get a little bit into the financial piece, back to what Mr. Strege had mentioned. But we're going to go in this order. We're going to talk about your right to make informed decisions, the need to plan for incapacity and end of life, the importance of having conversations and assigning roles with loved ones, which again reinforces what you had last month, and then again, as I mentioned, abuse, safeguarding dignity and well-being. Do they want life-sustaining procedures? For example, do they want to be put on a ventilator or have a feeding tube if they're not able to do those things? Who has the authority to speak for them regarding their medical care? Who can pay their bills? Who can decide if they need to go to rehab or somewhere else, need to be put in long-term care? Who can decide where they can be placed? What about their finances? Who's going to pay their rent, make decisions on their life insurance policies and those kind of things? And if they have children, who's going to take care of their children? Where do they want their property and personal belongings to go to if they do, in fact, die? And do they want to be cremated, buried, or an organ donor? We're all part of a death-denying culture. And so procrastination, unlike we might think, because I'll ask people, I'll say, well, why is it that you don't want to do this other than procrastination is? And that's that they're in denial. We're all in denial that these things will apply to us, and yet we know it's absolutely certain. And sometimes even when I'm visiting with someone who is in end stage of life, they tend to procrastinate sometimes too, because it's almost as if they deal with these issues, then they're acknowledging that they will die and that they're giving up their fight against cancer or a different chronic disease. And the opposite is actually true. Oops, here we go, sorry. Getting ahead of myself. Yep. The opposite is actually true. If you know in advance and deal with these issues, when you have peace of mind, then you don't have to worry about them. You can deal with all the pleasures of life. And the day that I can promise you, the day that somebody executes a will or power of attorney in my office and walks out the door, they aren't hit by a bus, they don't die, they actually have that peace of mind. In fact, in almost every case, they say, oh, this was really not that hard. I'm so glad to have that done. Why is planning for incapacity and end of life so important now? So what is the average life expectancy in 1900? Anybody want to take a shot? 65? No? 45. I think that perhaps Dr. Shah is familiar. 47.3 years. Now, what about in 2016? What's the average life expectancy now? 78. Okay, you guys are in the ballpark. Females, 81.53. Males, 76.59. And the average of 79. Average life of a terminally ill person in 1900. Any guesses? Anybody else? Actually, 3 days. You're long. You're double what it is. 3 days. Now, what would you say the average life of a terminally ill person is in 2016? 6 months? Anybody else? A year? Anybody else? 4 years. Okay, well, that's quite a range. Actually, and the data that we have is more from the year 2000, but over 90% of us will know 2 years in advance what we will die of. So we're going to have 2 years period of time that we're going to be in and out of the healthcare system that we will have points where we can make decisions and points where we cannot, or we're going to need a lot of care and a lot of decisions. So more so than the very end of life, it's that period of time when you're incapacitated for 90% of us that we need to be prepared for and we need to plan for and make decisions. Now, I would note that for that other 10%, there's situations like what I talked about here. You go out tonight and do get hit by a car for 10% of us, and so we all need to be ready. I think a lot of us do think this is something just more for those who are aging. This is for all of us. We need to be prepared. So we need to plan for death and incapacity. You're going to know what you want best, okay? If we leave it to someone else, sometimes that might be a judge or a different decision maker who may not have any idea about you or what you would want. It's most likely not going to be in line with your wishes. Again, I mentioned about timing. Timing is everything. You make better decisions. You have that peace of mind. And of course, we know that there are limited resources in the healthcare system, and so we have to make choices there as well. The general rule when it comes to healthcare for you is that you get to decide. It's what they call legal autonomy. It's a constitutional right that's been recognized by the American jurisprudence, but we know there are exceptions in the law to that. Certainly, other than a few states, prostitution, use of illegal drugs. We know there's, even for seniors, opioid use and marijuana are big issues, along with chronic pain. We also know that there are issues related to physician-assisted suicide. If it's something that relates to our body, we get to decide. There's also what's called the Patient Self-Determination Act. This is around 1990. They decided that it was important that all people, when they went to have a procedure done or into long-term care, that they would be notified of their right to make decisions, and that they would be asked about whether or not they have advance directives. So if any of you have been recently in a healthcare facility, they're always asking you, do you have any advance directives? If so, can you provide a copy for us so we have it? Because the only way an advance directive will be utilized is if the healthcare provider knows that they have it. The doctrine of informed consent, when we're talking about our bodies as seniors, and I think sometimes there's a tendency as we age for people who are younger to kind of forget that we should still be able to make decisions about ourselves, about our sexual expression, about other things. And so informed consent is something that we still need to have. All of this is subject, of course, if we have medical decision-making capacity. Basically, it's a conversation. The provider should be visiting with you about potential risks, the benefits, and the alternatives to what you're having. They need to have it in a conversation tone that you understand. They need to answer questions, and you need to be, and the reason I wanted to bring this up tonight is you need to ask those questions. If it is not clear to you, it's very important, and I think particularly with our seniors now, there's a tendency to trust our doctors and not want to ask questions. But you should be asking questions if you don't understand. So make sure you ask those questions, make sure they answer them, and if you need more information, ask for it. But the consent part alone is not enough. As I mentioned, you have to be competent, and without having information, then it's not enough. Here in Iowa, it means the condition of a person who's been adjudicated, another 50-cent word, by a court to meet at least one of the following conditions. And basically it says that their decision-making capacity is impaired, so they can't care for their personal safety, provide for necessities such as food, shelter, clothing, or medical care without physical injury or a bad outcome, or they can't communicate. There is a difference between competent and capacity. Competent, as was stated at the beginning of the last piece, is about a judge determining whether you have the ability to make decisions. Medical capacity is, do you have the ability to understand this healthcare related thing that we're sharing with you? Is decided, or at least recommendations are made relative to clinicians. So healthcare providers, the physician and others involved in that person's care. As I mentioned, this can be total. The person just really has no ability, or maybe in some cases never did, to make these decisions. It may be partial. Some decisions we can make, others we can't. Or it may be on some days with dementia, some days I'm very clear and I can make those decisions. And other days I'm really not with it, and so I can't make those decisions. All individuals, as part of that decision making, do have the ability to refuse life-sustaining treatment. Competent adults can refuse it. Even if it's in our best interest, we can do it. And if the provider actually does it against our will, that is battery. So providers should never move forward except there's an emergency exception. But in most cases, they should not move forward without either that person's permission, or if a substitute decision maker has legal capacity to decide on their behalf, that person's permission, other than, again, that emergency exception. A person can be held to be competent if they understand the consequences of their decision, even if the decision is not one a reasonable person would be expected to make. Substitute decision making is assistance that becomes necessary when someone needs help making financial or personal care decisions. So who decides in those cases? Substitute decision makers are sometimes called proxies, especially different states have different names for them. They have what's called a fiduciary. That means they have a legal and ethical duty to act on behalf of and in the best interests of the person who they're helping to decide for. They always have to act in good faith, and a key thing that sometimes gets lost, especially with children who have their own emotional attachments to their parents, is they need to honor the wishes of the person that they're serving. And you always want to maximize self-reliance and independence. I mentioned informed consent. Informed consent is the here and now. An advanced directive means that we're looking to the future and we're trying to decide, if I can't decide, then what do I want to happen? So advanced directives kind of have two pieces. There's actually many others out there too, but the ones we're going to focus in are durable power of attorney for healthcare, as well as for the living will. The living will is about what you want to happen, your intention, and the power of attorney is who you want to decide. Let's talk now about who some of those surrogate decision makers are. And these are, of course, we're talking here about healthcare. We have a durable power of attorney for healthcare. This is a competent principal. That means the principal is the person who's going to have decisions made for them in the event that they are incapacitated. That principal is competent, and they've signed a legal document designating a person who's called the attorney in fact to make decisions on his or her behalf. Now, a lot of people will say, Anthony is my power of attorney. Anthony is not the power of attorney. The power of attorney is the document. Anthony would be my attorney in fact. Now, a guardianship is where the court's going to decide. This usually, it can be done in advance, but typically somebody doesn't have capacity to make decisions, and usually they don't have the legal competency, and so the court will appoint a guardian to make decisions for that person who is called a ward. Now, there's limited powers that that court will give to that person. Even if they have a very broad one, there's still some things that the Iowa Code says, end-of-life decisions have to go back before the court. There's certain things that even if they give them very broad powers, some things still have to go back in front of the judge. Now, what if we don't have an advanced directive? It's not to the point where we need a guardian. Can my family members make decisions for me? We know that happens all the time, right? Yes, they can. Usually the spouse, then the adult children, then if they don't have adult children or a spouse, the parents. Sometimes there will be other relatives or even special friends. People who are involved in the care of that person can help decide. HIPAA does have an exception that allows those involved in your care to have access to your medical records and so forth so that they can make good decisions. So all is not lost if you don't have these advanced directives. And if you've had all sorts of conversations and things go smoothly, it can be just fine. However, I'm here to tell you that there are many cases in which there is disagreements. Here in Iowa, we have an office. If there's nobody to decide, then they do have this office, and then they have local people who can help to make decisions on that person's behalf. But generally in those cases, we turn to the healthcare provider who decides based on the best interest of the patient. Typically, the powers for health care are you can admit the person to long-term care, you can request a psychiatric treatment or invasive diagnostic tests, order dental surgery, withhold or withdraw life-sustaining procedures, which remember, guardians have to go to the court for that. You consent to a do not resuscitate order. You can apply for Medicare and Medicaid and other government programs or insurance, and you can access their medical records. How do we terminate? I mean, we want to make sure that there might be a point where it's not needed. Upon disability or incapacity, unless the document states otherwise, and I've been using this word durable. Durable is the word that means if they become disabled or incapacitated, that advance directive will still continue to be in place. It's important when you're signing a durable power of attorney that you understand what you're signing. You can put in there what things that you're authorizing them to do, and you can limit what those are. Remember that there's no court oversight. So if you really don't totally trust that person, then you may want to look at what's called a standby guardianship. You will decide what powers are designated, and so the document itself, the power of attorney, is the document will specify that. And sometimes it will be combined in one form with the living will. The idea of the power of attorney is that they're going to stand in your shoes. They're going to make decisions on your behalf and enter transactions on your behalf. There are public forms available at the Iowa State Bar Association website for the living will, power of attorney, and durable power of attorney for financial and health care, et cetera. Now, once you would execute that document, do you want to put it away in a vault or a safety deposit box? Well, you might want a copy there, but no, you want to have this accessible. What I used to do is I would make like a notebook that would have the will, and it would have the powers of attorney and the living will in it that could be on the shelf. Then I would make extra copies for the people who were noted as the power of attorney, and we'd have a copy of the living will. And then we'd even have a copy so if they went to the hospital, they had that as well. Some of you may already have those things in place, but over time there's some changes. For example, the HIPAA, the right to be able to have access to medical records, didn't used to be in the form, and now it is. So you might want to execute a new one. It's important that those are designated and that there's one person. You want to think about who is the most logical person. Maybe are they closer in proximity? Does one a nurse or a doctor where they would know more about health care or be more comfortable with those things? Is there one that really, even if they are a doctor or nurse, is not comfortable following your wishes, as we've talked about earlier? Is there somebody who's really good with finances, and they might be the best person? So who are the most logical people? And then you have alternates. I usually would have a couple alternates in case that person was unavailable or unwilling. So I just wanted to take one quick minute because I always get questions afterwards if I don't address this, and that is about wills and trusts and a little bit about probate. When the person passes away, the things that they have ownership or interest in are called the estate. That's all the property owned by the person. That includes real estate as well as personal property. The will is a legal document that directs where they want their estate to be distributed to after that person dies. A trust is a estate planning tool, and I'm basically reading this because this is what I want you to walk away with, that can replace or supplement or supplant a will, and it can help to manage property during your lifetime. Now, if you die without a valid will or having a trust, that means you will have no control over where your property goes. States will make decisions, and that's based state to state, but they're fairly similar, on how the property will be distributed to your relatives based upon your relationship to certain people. So what is this word probate? A lot of people say, I don't want to trust because I don't want to go through probate. Well, probate is basically, it means that they're going to take your estate and they're going to make sure that everything, for example, real estate, it's paid for, it's free and clear, there's a good title, so that it can be distributed to this other person without having somebody later down the line say, oh no, they didn't really own this property. And so they want to make sure that the title is clear and can transfer to the person. It takes the rest of the estate and disposes of it. Once that's done, they pay bills. They may get funds from others who owe that money. And the executor, who I mentioned before, is the person who oversees that. In addition to having your will and your healthcare decision-making and advanced planning, you also want to have a list of your different assets that you have. You know, we all have little savings account here, and we may have a life insurance policy there and here, and oh, there's one from work, but we didn't think about that. If you have in, for example, a notebook or one central place, and you make sure that your executor and also any other decision makers know where that is, then you're going to be able to do much smoother at that time. Two other quick things about estate planning considerations that are very important, especially if you have children who are minors, or if you have a child or grandchild or another family member who has special needs. So listen up, this can be very important. Now, when there is a will, then often there will be, if you have a child, a trust, and that money will go into a trust, and for many people, they'll distribute it a certain amount to different logical places. So after they graduate from high school, maybe they'll get a percentage. About the time they graduate from college, they'll need some money to get a job and a car, so a certain percent. And then when they're about 30 and maybe having their own kids, they might get the rest, or however the person decides to distribute it. What happens when there is no will and there are minor children who are entitled to inherit is they have what's called the Uniform Transfers to Minors Act. Basically, that sets up a trust, and all of those funds, and even if you think you don't have a lot of money, you have more than you think you do when you think of your home and your car and the values those bring. All of that money goes into that trust. So you think, oh, it's in a trust. That's good. Well, in this particular trust, they're very, very protective of those funds. So as that minor grows, most things that are over a nominal value, you have to go to the court to get permission. So it's very, very restrictive to accessing it until the child turns 18. When they turn 18, they get access to everything. And I've seen devastating situations where children have inherited everything when they turn 18 and went out and bought a sports car, went out and bought other things, gave money to friends, and ended up destitute. So not having a will can really be devastating, especially if you have a minor. The other thing is if you have somebody in your life who could inherit and has special needs, and special needs is a broad definition, but I used to do these kind of trusts, and I've seen cases where this goes terribly wrong. If somebody gets government benefits, Medicaid, they get a case manager and those kind of things, they are eligible based on the assets they have and the income they have that comes in. And if they suddenly inherit even a couple $1,000s, now they are not eligible because they have too many assets. And during that time, they've lost access to their case manager. In fact, in many cases, you can't even private pay. And I can't tell you how disruptive this is for that person. So if you have somebody in your life, I mean, you think, oh, I have this child who has special needs, I want to maybe give them even more. If you set up a special kind of trust for them with certain language, it can protect their access to that for certain kinds of things without disrupting their access to benefits. A living will doesn't necessarily mean that you don't want to have treatment at all. It can mean you just want to have what they call comfort care to keep you comfortable, or it may mean I'm comfortable having a ventilator, but I don't want to have other types of things. Or it may say, I want everything. It's just a clear statement of what you would like. Okay, I have these advanced directives that I did in Iowa, but I go out, like my parents live in Arizona, I go out to Arizona a couple months of the year. So what if I have my form there and something happens? Am I covered? I will note as a disclaimer that not all states recognize advanced directives from other states. However, most have language with some level of reciprocity where as long as there's not conflicts between the two, they will honor as much as they can of those advanced directives from the state where you actually enacted it. Some people will enact in both, having very similar documents from both states. And always bring those advanced directives with you. Again, it's a statement of your intention and who has authority to speak on your behalf. And I've given you, so if you've executed a living will, are we now guaranteed that our wishes will be followed? The answer is probably not. We've got the legal document, we've got the legal authority, but often that's not enough. If you understand healthcare, and I think most people don't understand this part of healthcare, the living will is not saying that the medical team now should not resuscitate somebody or should make these decisions. You still need to have generally a physician order that's going to tell that medical team, or if EMS shows up, tell EMS this person does not want to be resuscitated. So there needs to generally be a physician order that what I call operationalizes that legal document. IPOST is an Iowa physician order for scope of treatment. And this is a neat document that we have now that really makes it much more conversational with the provider. It's basically a complementary document to your other advanced directives, and allows the patient and their proxy, the person deciding on their behalf if something happens, and the physicians what they would like to happen. I've also referenced a couple times do not resuscitate orders. These are orders that say, I don't want to be resuscitated, and in certain circumstances. I would note that advanced directives and do not resuscitate orders generally are suspended during surgery or if there's an emergency. Sometimes people say, no, stop the press. I want everything possible. And so for those people, they're saying, no, I don't not want it. I would like you to try everything you can. I want to take every chance I can to live. And that's okay too. And so there's a physician order for that as well. So we have this protection, what's called an out-of-hospital do not resuscitate order. You have a special indicator, and basically that means that when EMS comes, they know what your desire is and they will follow that. Are the advanced directives and physician orders a sufficient guarantee? Well, maybe. But this is where conversation becomes important. It's not just a piece of paper. It has legal significance, and we've got the operational significance, but they're still subject to challenge by a determined family member. And having that conversation with your loved ones ahead of time is crucial, because I will tell you that if the physician is there and one child is saying resuscitate and do everything, the other one's saying not, and neither of them they both have authority, or neither of them have authority, or even if one has authority and the other doesn't, they're going to generally err on the side of resuscitating the person. Dependent adult abuse is a very serious issue, and I do a lot of talks for groups that are medical providers, and we focus in for several hours about how we recognize those signs and so forth. It's determined by state law. There's a difference between child abuse and dependent adult abuse. And so we're going to look to that code section and work with state agencies to address this. The dependent adult, they define what that is. That could be somebody who's a senior, or it could not be. Somebody who is older doesn't necessarily depend on other people in the household. So it doesn't automatically based on age. It's, are they dependent on others for their care and well-being? And there's the definition. Then they have the person who's the caretaker, which is defined as well. That can be for money or not for money. It can be voluntary. And then there's some basic areas of dependent adult abuse. There's physical injury, unreasonable confinement or assault, sexual offenses, exploitation of them taking unfair advantage of them for physical or financial resources, or theft, undue influence, harassment, duress, deception, false representation, or false pretensions. And then neglect, what we typically would call for child abuse, neglect is called the deprivation of minimum food, shelter, clothing, supervision, physical or mental health care, or other necessary things for care that are required for that person. And we also have another category of sexual exploitation. Last thing I want to just point out to you is some of the signs of things to look for. And I'll let you read them, but basically unexplained injuries, frequent illnesses that they've withdrawn or changed from how they normally do things. Their hygiene is not kept up. They're unresponsive. They don't have their basic needs. So you can take a look at that. And then what do you do if you do find that you have concerns? You don't have to confirm that there's abuse. If you have suspicion, then it makes sense to go ahead and report it and let the experts figure out whether or not it's something that's real or not. Err on the side of reporting it. So one of the things you're going to want to do to advocate for your person is pay attention to the care plans. Make sure that they're taking care of all those initiatives to get the person in the community and provide the things that they need. If you see something, say something, report it. Come and visit at different times. Don't always come at a really predictable time. Kind of check up on people, keep them a little on their toes. Document any concerns that you have. Go to a social worker, the director of nursing, or administrator of the facility. Contact Department of Human Services, or we do have a long-term care ombudsperson here in Iowa. So discussion about aging and death and dying is a reminder that life is not forever. And life is not measured by the breaths we take, but by the moments that take our breath away. It can empower our living each day, and I hope that you walk away today feeling empowered.